Welcome, everybody. So I'm Ann Daly. I'm the Associate Dean for Faculty Development and Intellectual Life here at the law school. And very excited to be hosting tonight's event on behalf of the law school. This is the first in our series of In Conversation, the Supreme Court, which we're going to be having throughout the year. Our next conversation is on November 15th, when we'll be discussing the SFFA against Harvard and UNC affirmative action decision. So hopefully you guys will be able to come to that as well. But today we're discussing the case 303 Creative against Elenis. And we have an amazing lineup of speakers here, and I'm going to introduce them very quickly so that we can get into our conversation. I know that students here, some of you have 6:30 classes, so we're going to try to end in time for you to get to those classes. So starting here to my left, we have Dale Carpenter. He's the Judge William Hawley Atwell Chair of Constitutional Law, Altshuler Distinguished Teaching Professor and Professor of Law at Southern Methodist University Dedman School of Law. It's a mouthful, where he teaches and writes in the areas of constitutional law, First Amendment law, and LGBTQ rights. Catherine Franke is at the end of our panel. I'm introducing alphabetically. She is the James L. Dorr Professor of Law and Director of the Center for Gender and Sexuality Law at Columbia Law School. She's also the founder and faculty director of the Law, Rights, and Religion Project and the ERA Project. She writes and teaches in the areas of law, sexuality, race, and religion. Craig Conniff is here next to Dale. He is the Martha Lubin Karsh and Bruce A. Karsh Bicentennial Professor of Law at the University of Virginia School of Law. He writes and teaches in the areas of health law and policy, property and sexuality, gender identity, and law. And Ria Tabako Mar, sitting up last, so I don't have to point out where you are, right next to Catherine, is the director of the ACLU's Women's Rights Project. She led the ACLU's team in Masterpiece Cake Shop against Colorado Civil Rights Commission, which some of you might remember. It was the case in which a same-sex couple was refused a wedding cake, and really is the precursor to today's case on wedding websites. So briefly, this lawsuit, Lori Smith is a Colorado resident who owns the business 303 Creative, which is a website design firm. She decided that she wanted to expand her website design services to wedding websites, but she has strong religious objections to same-sex marriage. Because she believes that same-sex marriages are false, she's unwilling to create same-sex wedding websites. So she wants to offer wedding website services to the public, except not for same-sex weddings. Like almost every state, Colorado has a public accommodations law, its Anti-Discrimination Act, that prohibits anyone engaged in the public sale of goods or services from discriminating on the basis of protected characteristics, including sexual orientation. Smith was not yet providing wedding website services, but she preemptively brought suit against several state officials, including the Colorado Attorney General, for a declaration that the act violates her First Amendment right to free expression by forcing her to create wedding websites for same-sex couples. She argues that the law compels her to express support for same-sex marriage, violation of the First Amendment. So that is, it's actually almost impossible to give you a neutral version of the facts. And in fact, I'm going to start our panel discussion by a quote from Justice Gorsuch's majority opinion, which indicates that the majority in dissent seemed to be viewing this case they're really almost worlds apart. Actually, I have a quote from both the majority and the dissent. Justice Gorsuch says, "It is difficult to read the dissent and conclude we are looking at the same case." And Justice Sotomayor in dissent writes, "The court reaches the wrong answer in this case because it asks the wrong questions." So I'd like to start our panel off by helping us to understand these two worldviews and what exactly they're sort of disagreeing about, how they're seeing this case differently. And I'm going to start, Dale, with you. I thought you could help us just sort of briefly describe the majority, Justice Gorsuch's view, and then we'll go on to hear the dissent.
Sure, I'm happy to do that. First of all, I want to thank you for inviting me today. It's a real pleasure to serve on a panel with these very distinguished scholars, all of whom I know by reputation, but I don't believe that I had met before, so it's a great pleasure to do that. Closer to my mouth. Can you hear me? Of course, if you couldn't hear me, you wouldn't know to answer, so hopefully you can. Justice Gorsuch's opinion. It's not a terribly long opinion, and I think in part it's not terribly long because there were no really serious disputed facts in the case. And so one of the things that Justice Gorsuch begins his opinion by noting is that there were several really critical stipulations that were made by the state of Colorado, concessions, if you will, to the case brought by Lori Smith and her lawyers. Among those concessions or stipulations was that Lori Smith wanted to engage in a business offering a product, the wedding website designs, that were expressive in nature. They were unquestionably expressive in nature, and the reason for that is that the designs involved text, words, they involved images or graphics, they involved sometimes videos, carefully curated. The other thing that was also conceded and stipulated by Colorado is that the designs that Lori Smith was going to be offering or proposed to offer to the public were designs that she was going to work closely with her customers on. They were not just come and get a website, it's pre-designed, take off the rack a kind of preset, pre-made websites that I'm going to sell you. It was very carefully curated and edited for those specific customers. So she's working closely with these people. Another stipulation that was made by Colorado is that Lori was, through these wedding website designs, going to promote her own vision of marriage. So this would be, in a very important sense, her own speech. It's a particular vision of marriage that she draws from her religious views. Another concession that was made, or stipulation that was made by Colorado, is that she agreed that she would sell any other kinds of services to gay and lesbian customers. She simply objected to the message, the promotion, or the celebration of the marriages that she did not believe were appropriate. So those were all things in the stipulations and the facts. Additionally, and there were about 9 important concessions in Justice Gorsuch's opinion, but 3 I think are most important. The last one is that Justice Gorsuch pointed out that Colorado stipulated that customers would know that the designs that she made were made by her, that she had designed these websites, and so they would associate these expressive designs with her, not necessarily just with the customers or anything of the like. So while they might be the speech of the customers, they were also, in a sense, her own speech. They were co-creators of these wedding websites. That was her proposal. That was not contested. At that point, Justice Gorsuch noted that, generally speaking, with some exceptions for purely factual information and uncontroversial information, the government cannot compel speech. The freedom to speak includes the freedom not to speak. It also includes the freedom not to have to create speech or to be compelled by the government not to create speech. With that as the general principle, Justice Gorsuch relied very heavily on a couple of important decisions from about the past 30 years in the Supreme Court. One of them was a decision in a Boston parade case known as Hurley that some of you may have heard about, in which the court said that the application of a public accommodations law to a private parade was unconstitutional as an infringement on that particular parade's message when it rejected a gay and lesbian contingent in that parade. The second was the Dale case. Yes.
I'm just going to interrupt because you've done a fantastic job kind of laying out
Yeah.
both the role of the stipulations and also the general framework here, which is that this is compelled speech. She is being forced to speak in ways with which she doesn't agree. And then I think we can get into some of the cases, but I wanted to give, and Rhea, I don't know if, I want to give you a chance to sort of paint the portrait of how either the dissent, really the dissent in the case Sotomayor sees this differently.
Thank you, Anne. And I'm a New Yorker. I tend to talk very fast, but Dale is inspiring me to try to slow down. So I'm going to do my best to not run away with this. My favorite line in Justice Sotomayor's dissent is actually a different sentence, and it's the one where she says, "What a difference 5 years makes." Because the 303, as Anne previewed, essentially raises the same question the court considered 5 years ago in Masterpiece Cake Shop, whether a business that opens its doors to the public can turn away a couple simply because of who they are. And in Masterpiece Cake Shop, though the court did let the bakery off the hook for its discrimination against our clients, Dave and Charlie, it didn't change the settled principle that the answer to that question generally is no. And in 303 Creative, we've got a very different answer. The only thing that has changed in the last 5 years is the composition of the United States Supreme Court. When Sotomayor says that the court, the majority of the dissent are asking different questions, the dissent was trying to situate this case well within the court's traditional First Amendment jurisprudence, which says, the question isn't, is a website speech? Rather, the question is, what is the government trying to do here? Is this a regulation that targets speech, in which case it receives heightened First Amendment scrutiny, most often fails? Or is this a regulation that's really aimed at some other problem and only incidentally burdens speech? Here, the Anti-Discrimination Act clearly does not target speech or expression. It's a law that dates to 1885 and was originally intended to ensure that recently emancipated slaves had equal access to the marketplace. That is not a purpose that targets speech. And so the law should not have received any kind of heightened First Amendment scrutiny. Interestingly, the majority also does not apply any kind of heightened First Amendment scrutiny, but really creates sort of a per se rule, which it says is compelled by some of the stipulations, that when there is a conflict between the First Amendment and a state law, that the First Amendment must trump. And that rule, I think, is impossible to separate from the composition of the court and from the line of cases where, when the court has been confronted with challenges between the First Amendment and the rights of LGBT people, consistently it has been LGBT people who have lost time and again. And that, I think, is the real rule to discern from 303 Creative.
Craig, do you agree with Rhea that the question, that there's no, because the government is not targeting speech, I think that's, it's targeting discrimination, I guess we'd say, that the First Amendment really doesn't come into play here? And that may be overstating Rhea's point, but do you agree? Turn it on.
So the First Amendment has always been in conflict potentially with anti-discrimination. When these cases sort of really started coming about, I thought of this famous article written by Herbert Wexler, Towards Neutral Principles of Constitutional Law. And in a portion of that article, where he's writing about the Brown versus Board of Education decision, he talks about the associational rights of the students involved. And he points out that segregation involves associational rights, and that when you prevent students from associating with someone of the opposite race, that affects associational rights, but when you force them and integrate them, that affects associational rights. And then he goes on in various ways. And of course, the civil rights movement involved numerous conflicts between the First Amendment and civil rights protections. I think that you know, if you look at Ollie's Barbecue, right, it was one of the restaurants that wanted to exclude black people. The point that many took from the claim that he didn't want to serve black people was that the very selling of products to black people was an expressive act. If he sold products to black people, it said something about where he stood with respect to black people. So if you extend the First Amendment in the way that I think the court seeks to do, every act can be an expressive act. And so I think you look at the statute itself, right? And you look at its inception and its purpose. And so I do tend to agree with Rhea that the protections are incidental. And I think that the analysis that should have controlled is the analysis, can I talk about cases yet? Yeah. I don't have to.
Please do.
Okay.
Yes.
All right. So was the analysis that we see in the Fair versus Rumsfeld case, right, which is the case that involved military recruiters on campus. And their law school said, you know, look, we've got to send emails talking about where the recruiters are going to be, et cetera. And at the time, the military had a policy referred to as don't ask, don't tell, which basically discriminated against gay people serving in the military. And we don't want to be associated with the military. And when we have to engage in speech that promotes what the military is doing, we are very much being associated, right, with the military. And I know that we felt that they were associated with the military because I was one of the law students protesting, right? And we associated our schools with that speech. Now, in this particular case, and I do want to go back to the facts for a second, no couple, straight or gay to our knowledge, actually had asked the designer to make a website. The designer had never, in fact, made a wedding website before. And so I do think that there are certain questions and problems with the stipulations. But in this particular case, I think the case to some degree was manufactured. I think that the court engaged in some very questionable approaches to standing, to the question of standing. In fact, when Justice Sotomayor raised the question of standing in her dissent, the majority simply said, well, the 10th Circuit said there was standing. And so I think that in this particular case, the facts were, if I may deploy a pun, unbaked, right, in a gay or straight way, right? And I think that I think that the court took advantage of that to move forward with a certain approach.
Catherine, I bring you in at this point. You want to comment on anything that you've heard?
Say anything.
No.
Okay. But I will also add my thanks to you, Anne, and to the Dean, and to all of you for welcoming us here today. I have to say, I talked a lot about this case last spring when the case came down, and last June. I think all of us did a lot of media on the case. It's been refreshing to be able to take a break from it for a couple of months. So it's nice to return to it with kind of fresh eyes. I think what we're also seeing in this case is a ingenious litigation strategy that the Alliance Defending Freedom, Liberty Counsel, and some of the other evangelical Christian legal organizations are taking, which is that they're bringing these pre-enforcement actions where there are no injured plaintiffs or parties who come before the court as a gay couple or an individual queer person, so that we consider their interests, their lives, their stories, the reasons why we have anti-discrimination laws in the first place. So the case from just before 303 Fulton versus City Philadelphia did the same thing, where there was an issue of a Catholic foster care agency saying that it wanted to be exempt from having to vet same-sex couples, or actually anybody other than a heterosexual married couple, for placement in the as parents in the foster care system in Philadelphia, because they were Catholic and they believed that heterosexual married parents were better. But there had not been a case, an actual couple who had been refused, that were part of that litigation. What it does is it tees up so nicely the idea that Christians are being persecuted, which is Justice Gorsuch's issue. He's talked about it both on the bench and off the bench. I know he and Justice Alito believe this very deeply, that Christians have been affirmatively persecuted in a range of contexts, including by the law. And so the absence of a real same-sex couple who sought a wedding website who was denied by Lori Smith renders those interests and the state's interest in enforcing human rights laws or civil rights laws invisible to the court. And it makes what is visible is poor Lori Smith, who's a God-loving little businesswoman from Colorado who doesn't have animus towards gay people, as Dale said, happy to do something else for a gay person, but just not weddings. And it's what we teach our law students on the first day and through all of law school is once you get the upper hand as an advocate in framing what's at stake and whose interests are really key to this question, you've done 80% of what you need to do to win. And ADF has been very effective in doing that. Same is true in the affirmative action cases that we also had this term. This court finds it impossible to see discrimination in communities like the queer community, LGBT communities, or with people of color, no matter how hard, even like in the affirmative action cases, we can present evidence of historical discrimination in access to higher education, or in the voting rights cases, historical evidence of very clear discrimination against people of color in voting. Even that evidence is invisible to this court when those parties are actually present and there is evidence of those forms of discrimination. So if they can't see it there, they certainly aren't going to see discrimination and worry about it when there isn't even a party present to say, we're a loving couple like anybody else, we'd like a wedding website. And I can keep going, but I'll stop if you want.
So I want to let Dale, respond. I guess, it's interesting that you talked about the stipulations, and we're all kind of curious, I think, well, what if the stipulations hadn't been there? Would the case have come out differently? What's coming down the pike? But with respect to the question of whether, in fact, we would say there was expressive interest here. This was compelled speech of some sort. And, I think, Craig, you're saying, when you were a student, you were actually making that kind of an argument with respect to the military recruiters. We could say that also in the case involving, now the name of it is just escaping, the Runyon against McCrary case, which is the case about the school that was excluding black students. And so the question there was, well, they're being forced to open their doors. And we said, well, that's not really about speech. I think that maybe, we recognize that there are expressive elements to all of this. And I think, Craig, you were saying that. So where does the First Amendment, I wanted to give you a chance, Dale, to talk about the First Amendment interest here and how because as Craig says, this is just going to open the door to, well, then anything goes.
Yeah, so I think that's a reasonable fear, especially as the decision is applied in the lower courts. I think there's reason to be concerned about what some lower courts might do, district courts, maybe even a couple of appellate courts. What I would say about that in general is I think the way we ought to look at this decision is that it requires a number of different things before a business person can make a successful claim. One of them, I think, is that the claim would have the product or service that's being offered and that the business owner is saying, I don't have to offer, is a product or service that is expressive, and that has a meaning in the court's jurisprudence, and it's a product that is customized. Very, very few of the ordinary goods and services we buy in the marketplace are those kinds of things. When you walk into a restaurant, when you want to be employed by someone, when you're trying to enter a school, You're not engaged in an expressive act or seeking expressive services. The courts have repeatedly found that. So I don't think that most of these cases should arise, but there's some danger that some courts will misinterpret the decision. Second thing I think is that the objection that the owner makes has to be not to the status or identity of the person who is requesting the goods, but to the message that is contained in the product. So the First Amendment does not protect conduct, it protects expression. We have to decide what that means, but we have to get that principle straight, I think. So those are limitations on this decision, and I think those can be very important limitations in the decision. I don't think, for example, Runyon versus McCrary applies because the court specifically said there that when you're educating, when you have a class that you're considering for admission, your expressive interests do not arise. That is discriminatory conduct. It did say, however, that the school is free to teach whatever doctrines it wants, including the doctrine that it supports segregation. Even odious concepts are protected under our First Amendment. So the big issue, I think, that's raised by this case is what kind of a restriction was Colorado potentially imposing on Lori Smith when she entered the business? Was it something that really did substantially burden her speech, or was it something that only incidentally burdened her speech, incident that is to a larger non-discrimination purpose? And I think when you look at that, the court had the better of the argument on both the Boy Scouts case that I was about to describe and the Hurley case, when the court said, yes, you've got public interests in non-discrimination and allowing gay and lesbian people to participate in society, but at the same time, these organizations have private expressive interests. And the restrictions on these organizations, the Boy Scouts on the one hand and the Irish Parade organizers on the other, these were not incidental restrictions. They were substantial direct restrictions on their speech. And even a public accommodations law has to give way. If there is a conflict between the Constitution and a statute, there is no question about which prevails. The key question, I think, is the question of whether there is a conflict.
Go ahead. Yeah.
I know, because I disagree with a bunch of what Dale said, and you may too, so.
I don't know where to start. I'll start with one thing I agree with. I agree that the court lays out several factors that I think are important limiting principles on its decision, although unsurprisingly, I disagree with Dale about what those are. But one of the distinctions I think the court, that will become really key, is the court said that these websites were Lori Smith's own speech. And this, I think, really dovetails with the sort of pre-enforcement challenge in the stipulations, because I do feel compelled, footnote, to raise a sort of small but modest defense of the pre-enforcement challenge, which is something that we at the ACLU employ very often in the free speech context. What I think is different about this pre-enforcement challenge, in the typical case, you have an existing course of conduct and a new law. So for example, in our challenge to Florida's Stop Woke Act, we have people who teach educators, and they say, you've passed this new law that restricts what I can teach about race and gender, and I think this new law is going to impinge on, what I would ordinarily teach in my class. In this case, we have a very old law, a law that dates to 1885, or perhaps you might say 2008 when sexual orientation was added, and a new course of conduct, which is now I want to start offering wedding websites for sale. And the problem with that flip is that now we don't know what her sale would actually look like. And so in cases that where ADF has represented operational businesses, they have conceded in deposition and elsewhere, as I think they must, that ultimately the customer has the final say over what the product looks and sounds like, because of course that's the service the customer is paying for. I am paying you to design a wedding website, and I want the site to say, Rhea and Robin forever, and you say, I think that's sappy, it ought to say something else. I might agree with you, but if I don't, I'd probably hire somebody else to create my wedding website. And that's going to be true in operational businesses, not true, right, in this context where the business itself is wholly fictional. And so that's one of those key distinctions that I think it's in the majority opinion, and I think it's just not going to be true for real businesses that are functioning in the world, because that's not the good or service that we purchase. I also just had to drop a footnote about, the objection to the status. I think, I agree with something Catherine said earlier, that the majority has a sort of the stubborn refusal to see discrimination where it exists. the stubborn refusal to see discrimination where it exists, right? And when you say that the owner does not object to the status, it immediately calls to mind a different Civil Rights Act case, Piggy Park. This is the case, of course, of the barbecue restaurant that served black customers the same food as it served white customers, but black customers were served only at the takeout window, and dine-in service was reserved for white customers. And the owner said, I don't object to black people. I object to the message it sends by seating black and white customers together in my restaurant, which sends a message that I approve of integration when, in fact, I believe that integration, quote, contravenes the will of God. So, and we all saw that as an objection to the race of the customers. And here, that refusal really, I think, comes back to the court's refusal to treat discrimination against gay and lesbian people on the same terms as it treats discrimination on the basis of other characteristics. I'm just going to let Catherine jump in.
I guess should we just go in order again? Okay. So, okay, yes, I will.
And I lose.
No, you can go ahead. Go ahead. Okay, so, 4 points, which I'll pretend are 3. How about that? But I guess the first is on the facts, right? I mean, and saying that this case involves only something that is clearly expression. I think, first, I think Ria's point is well taken because, I think about spokespersons for companies, for example, or for governments or whatever, right? I mean, the spokesperson writes the speech to a large degree, right? I mean, but the speech is often, in fact, to my knowledge, always attributed to the entity for whom the person is speaking. But beyond that, what's interesting is that the court, after its decision, vacated and remanded an Oregon case involving cake, right? There was, again, a very similar case to Masterpiece that, in fact, began litigation before Masterpiece that had gone up to the Oregon Court of Appeals. The Oregon Supreme Court declined review. So very similar procedural position to Masterpiece. But it ultimately, the cert petition was filed at the same time as 303 Creative. And the court vacated and remanded the case for consideration in light of its decision in 303, right? Now, the court's, vacatur and remanding isn't always, I think, an instruction that the decision was wrong. But I certainly think that it's instructive in this case, and many of the limiting principles that Dale referred to, I don't really see that in this particular opinion. The second point I want to make is about discrimination. Why does Laurie Smith object to marriage equality? Right? Now, I am not someone who wants to say that marriage is the be-all and end-all of what it is to be gay, lesbian, queer, trans, whatever. I don't want to say that, and I don't believe that, right? But to my mind, the reason that there is this objection to marriage equality is that there is an objection to gay people. There is a moral judgment being made about the kind of affection, love, intimacy, right, that is at stake here. Now, and so we can talk about status and conduct, but again, I think it goes back to Ria's point and to the points that Catherine made earlier. I mean, this is a bit of gaslighting to say, oh, there's no discrimination here, right, against gay people. The only people being discriminated against are religious people who've not been asked to do anything. Moreover, it is a different kind of discrimination than the cases that Dale mentioned. So if you look at the previous cases, Hurley, Dale, right? I really want to talk about Craig versus Boren now, but but in those cases, you're referring to you're seeing private entities who are trying to use the First Amendment as a shield. I still believe there was discrimination in those cases, but they were saying, look, within our group, within our community, within our organization, we want to be able to discriminate, right? But we aren't trying to take that discrimination into the public sphere, which is what's happening here. And so that really gets me to my third point, if I can pretend that it's only my third point, but perhaps my fourth, which is that what is it that we're talking about here when we're talking about the burdens that that Laurie Smith or someone else who's trying to sell the products to the public is experiencing? I'm not trying to deny that there is a burden there, right? And I think that Gorsuch raises a parade of horribles as to, various other individuals who'll be forced to do various other things for people they don't like. And I think part of the issue here is that we've got to make a decision as to what values as a community we believe are sufficiently important that we all agree on, right, when we enter the commercial sphere. Some of those values are we don't discriminate against black people, right? And the Piggy Park decision, for example, was correctly decided. And I think that that there are gay people, that when it comes to gay people, there is still this conflict, there is still disagreement as to whether LGBT people quite reach that threshold. And it simply cannot be that someone objects really a lot because of religious or other reasons to a law, because I believe that there are businesses that object even more to other provisions of other laws, right? That provisions that might cost them millions and billions of dollars, right? Provisions that might require them to provide all kinds of documentation, paperwork, to say certain things, to write certain things, right? And I think that if we restrict this case to the facts, and even if we agreed on that, then I think it would be very problematic in a way to say that in every other area, the First Amendment does not trump, but when it comes to LGBT people, there's a special rule.
So, it's just a civil procedure moment. I think this is civil procedure. We're going to this question of stipulation, and I think there'll be some, and there already has been quite a bit of critique of what the lawyer defending the state was willing to stipulate to. One of them that Justice Gorsuch relied on very heavily is that the state stipulated that what she was engaging in was pure speech. It's an interesting thing that the state can stipulate to a legal fact, not a fact. And typically, that's the kind of thing that the courts decide, is this pure speech or not the parties themselves. And so that sort of launches the story for Justice Gorsuch and the majority of the court, is this is pure speech, and it's just like the Barnett case where the Jehovah's Witness kid didn't want to be forced to have to say the Pledge of Allegiance every morning. Given that stipulation of pure speech, those two things seem to at least plausible analogies, which of course they have nothing to do with one another and are easy to distinguish. So the stipulation part, I think, is quite interesting, and I think it's something for us to think about more generally in terms of just the flaws of legal reasoning in this decision. I do agree that there were stipulations related to the amount of creative ownership she might have over websites she produced, but nothing in the majority's opinion rested on that. It does no work. So in terms of a limiting principle, as this opinion is applied in the future, the degree to which there's something customized, special, particular that the creator, the owner of the business is doing for each individual customer plays no role in the holding of the case at all. So we can imagine many businesses that curate an experience for their customers. Many businesses do this on a wholesale, not a retail or particular level. Applebee's is a family restaurant. They can have an idea about what it means to be in a family dining experience that would leave out some families. There are religious theme parks, the Holy Land theme park, that might want to create a biblical experience for the people who come there, which would not include Jews who are on the outs in certain biblical stories, but it might be an experience only for Christians and maybe some Muslims, but they could have a religious story that they're producing as part of their business model that would on its face discriminate against certain other religions. So too a plantation-themed experience, whether it's a theme park or restaurant, you don't want free black people wandering around in a plantation-themed theme park or restaurant, and those exist too. And to the extent that they're creating a kind of experience for their customers, and then the state is telling them that they can't speak that story, because it discriminates on the basis of race, religion, sexual orientation, you name it. Those businesses as well will be emboldened, I think, by 303 Creative, and we're already seeing those cases. The last thing I'll just add in terms of where I think we need to press this decision in terms of the sloppiness of its reasoning is that it's not true that when the Constitution and a statute conflict, the statute must yield. When there's a constitutional right that is burdened, we apply strict scrutiny. And the court says, here, strict scrutiny applies, and then they don't apply it. They just say, she wins, right? And the court is more than happy to apply strict scrutiny in cases like Hobby Lobby to find the state, all sorts of presumptions that they use there, but to find that the state does not have a compelling interest that's furthered in narrowly tailored ways. But where this goes even further